Hey, what's up? What's up? It's your girl Neek, and you're tuned in to Neek at Night. And tonight we're going to be talking about the YSL trial and the defense getting a big win in the case. Now, they have been knocking down a lot of what the DA's office has been trying to do, improving their case, making it very difficult for the state to prove this RICO. And today they made it that much harder for them to be able to do so by knocking out one of their key witnesses and preventing him from being able to come back and testify and eliminating a lot of his evidence that he presented. Now, I'm a person who watches the trial, and I have an objective lens in my view of watching any trial. Now, whether I feel like the case is weak, whether I feel like, oh, this person should win or that person should win, I have the capacity to look at a trial and be able to see, okay, the state made a good point right there. Okay, the defense made a good point right there. And if the state is doing anything shady, I'm able to point out and feel like, okay, that was a little shady right there. That shouldn't have happened. That was foul. It should have been a mistrial here. The defense made a good point here. Maybe that argument wasn't the strongest. And I'm able to look at the trial with a very objective lens. So today was just like any other day that I was watching the trial. I started out watching it feeling like the state was connecting a lot of the dots as it pertains to a lot of the allegations that they were trying to prove in their case. They put on Detective Dennis, and he had been on the trial for, I believe this is his third or fourth time appearing in the trial. And he was able to connect a lot of the prior testimony that felt irrelevant. So the other day they put on YFN Lucci's mother on the stand. Her testimony felt irrelevant. They put on Woody's sister on the stand. Her testimony felt irrelevant. They put on 19 witnesses in one day, and together their testimonies did not feel like it had any substance. However, when they brought Detective Dennis to the stand, his testimony connected a lot of the dots and it pieced their things together. So today I felt like the state started out strong in what they were asserting and them trying to connect certain dots. Now, I still feel, however, I don't think that they have proven necessarily the RICO, but I feel like they have proven that there was a gang war between If Gang and YSL. Now, have they proven whether or not Young Thug is this big mob boss and he's calling the shots? I don't feel like they've proven that so far, but they have proven that there is evidence against some of the defendants in the trial, and I'm not about to be a stan or oblivious to act like I don't see it. Now, they have shady tactics, unethical means that they try to prove some of these things, but the judge has deemed the show must go on, so it is going on. Now, today, like I said, it started out strong for the state, and then the witness said something that he was not supposed to say, which caused them to throw out his entire testimony for the day. And his entire testimony today was very strong, in my opinion, making it a big loss for the state and a big win for the defense. So let's get on into it and watch what's going on. So this is the testimony. He has already been testifying, and there is a glitch in the audio. So basically, anytime they show an exhibit, it was kind of muting the audio for the viewer to see. And this was them kind of showing different pictures and different disrespectful stuff that has been going on. So let me kind of show you. So they're showing Yak Gotti right now, and they're also showing how he was disrespecting If Gang. Like, he went up and He was standing on YFN Lucci's car as a sign of, you know, you could get touched, we this close to you, and all of those things like that. And they were making a lot of headway with his testimony and proving certain things. So let's listen in, and then they end up calling for a mistrial.
Now, looking at State's Exhibit 1 TT, why was
All right, so right here, that is him standing on top of YFN Lucci's car, I believe. And this was a big key piece of evidence. Now, what ended up happening is when they showed, I guess, this exhibit on the screen, when they showed it to us, the viewer, it muted the audio. So we didn't get to hear what the witness said. So basically what he ended up saying was that this was one of the times where Yak Gotti was in and out of prison. Now, he wasn't supposed to be saying that, you know, or mentioning that he was in and out of prison and he's a detective. He's not supposed to be mentioning that. So an issue is now being raised to the court. All right, so Doug is going to ask for a mistrial.
Mr. Weinstein.
Your Honor, this one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice. They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Here, whatever response the state might be able to make on that.
Your Honor, that was not the state's intention.
I'm sure it wasn't.
Your Honor, that wasn't even, that response didn't even come across my mind that would even have come out of our witness's mouth, Your Honor. The state's intention was to solely talk about the vehicle that he was standing on and the fact that he was standing on that vehicle. If you can just give us an opportunity just to look at some case law just to see if we can.
Your Honor, I'm sorry. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out. I do not believe that the state intended to elicit that, and I think that you actually yourself acknowledged up here at the bench that you don't believe that was the state's intention.
I do not believe it was their intention.
Nonetheless, it happened. Yeah. I'm going to give y'all about 15 minutes or so to find whatever you might be able to find.
Thank you, Your Honor.
All right.
Thank you.
All right, so after this, they went on break for about, I want to say like 30 to 40 minutes. And then they came back and to argue their arguments and their points about it. So let me move on over in the stream to go to when they come back. And the judge hands out sanctions. Now, let's see. I think this.
Yeah, I know. All right. What is the state?
Yes, Your Honor. The state will ask that you deny defendant's motion for a mistrial. The state would like to cite the court to Swims v. State, which is 307 Georgia, 651, a 2020 case, Your Honor. In that case, which was the defendant's only enumeration of error, and I'm in Division 2 of that opinion, Your Honor, Swims contends that the trial court erred in denying his motion for mistrial after his character was improperly placed into evidence during Chelsea Owens' testimony. When the state asked Owens if Swims offered any reasoning for why he wanted to escape, Owens responded, and this is what the witness said in that case. I asked Swims, why would he do that? I said, why would you want to do that? He told me because they did not honor his fast and speedy trial. He was looking at getting off on a technicality because they didn't honor that. He didn't have that for his defense. He said he was doing time. He had a lot of time in West Virginia that he wasn't never going to get out. In that case, Swims' trial counsel immediately asked to approach the bench and moved for a mistrial. The trial court judge overruled Swims' objection and denied his motion. The state resumed its direct examination of Owens, who then testified that Swims provided another possible motivation for attempting an escape, that Swims had murdered Clemson. I asked him, did y'all kill that child? And he told me, why do you want out of here so bad? So that was how the testimony continued. I'm going to skip down. A trial court's denial of a motion for mistrial based on the improper admission of bad character evidence is reviewed for abuse of discretion by examining factors and circumstances, including the nature of the statement.
Slow down reading, please.
Sorry. The other evidence in the case and the action taken by the court and counsel concerning the impropriety. And they cite Smith v. State, 302 Georgia, 699. A passing reference to a defendant's incarceration does not place his character in evidence. And they cite Lewis v. State, 287 Georgia, 210 at Penn site 212. Furthermore, Owens' passing reference to Swims' incarceration in West Virginia for an unstated crime was an unexpected answer to the question asked by the prosecutor, who was attempting to establish that Clemson's murder was the reason Swims wanted out of jail so bad. And they see Walker v. State, 282 Georgia, 703. A non-responsive answer that impacts negatively on a defendant's character does not improperly place his character in issue. After Swims' mistrial was denied, the state did not inquire further into Swims' crimes in West Virginia beyond a single confirmation that his incarceration there also served as a motive.
All right, she says a lot of nonsense, so I'm going to speed up the playback on her.
The state's intention when I asked the question, what was the significance of that picture of the state's intention was solely to talk about the fact that Mr. Kendrick was standing on that car being that of Rayshon Bennett. His mother had identified that car yesterday during her testimony, Your Honor. So it was an inadvertent response, which was not responsive to the state's answer, Your Honor. And given that is what occurred, Your Honor, the state would ask that you deny their motion. Furthermore, Your Honor, other factors that you look at in order to determine whether or not a mistrial should be granted is the nature of the statement, other evidence in the case, the actions taken by the court. The what? The actions taken by the court. Was the reference isolated and brief, and whether the jury exposure was repeated and extensive, and was it inadvertent? Additionally, Your Honor, within the indictment, Your Honor, we did charge Mr. Kendrick with, as one of the overt acts in this indictment, which is Act 58, and he's also charged in this indictment in count 63 of this indictment, Your Honor. Possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. Your Honor, so for the purpose of having to prove that count of the indictment, we will have to enter Mr. Kendrick's certified copy of his conviction, of course, with a limiting instruction that only be used against him, Your Honor. So the fact that came out during that testimony will not be substantially more prejudicial, Your Honor, given that, one, the jury has heard this indictment, and as well as this evidence will come out. We said he was convicted because we have to prove that portion of the indictment, Your Honor. So we will ask that the court deny his motion. All right. And we have instructed our witness. Okay, so Ms. Weinstein.
Thank you, Your Honor. In the Swims case cited by the state, correct me if I'm wrong, but I do not believe that was a seasoned officer that testified about the bad character. Is that correct?
I don't know if it was seasoned officer.
Yeah, no, I looked. It's not.
It's an inmate.
You know, it's so funny because Doug Weinstein is normally like, his approach is like sweet and nice, and you know, he's no nonsense when it comes to like filing his motions and being an advocate for his client. But normally his approach is the sweeter approach of the attorneys. So when it's time to see him in action and really going blow for blow on behalf of his client, it was definitely exciting to see, because we don't normally see this side of Doug Weinstein. Like, he's normally chill and, you know, all of those things. So when he was really ready to give it up, child, it was exciting to see.
Right? And I think there's a distinction between a fellow inmate and an officer with decades of experience. And it's not just I that think that. I mean, I think if you go back and look at Posey v. State, which you may have already looked at, 152 Georgia Appeals 216, there you have a case where a seasoned officer testified about bad character of a defendant. The court in that case called for, there should have been a mistrial. It says that when it's impossible for the trial court by corrective instruction to rectify the harm done by improper testimony, a mistrial must be granted. And again, the issue here is you have a seasoned officer, someone with years of experience testifying. And in Posey, there's really very instructive language from our courts where they say, we reiterate here.
All right, and the client that he is advocating for is this guy right here in the beige tan or whatever. He looking like, I'm proud of my attorney, okay? But he was the one that was standing on the car, and he has a lot of evidence against him. I think that the ones that have the most evidence against them so far are Shannon Stillwell and Yak Gotti. Their names are the ones that they should have been the head of the dang RICO, not Young Thug, okay? But Young Thug is the one with the money, so they put him at the top. But Shannon Stillwell and Yak Gotti seem like the shot callers of it all to me, based on the evidence that has been presented. But let's continue.
I'm sorry, I'm talking too fast.
And too loudly.
Yeah, you know what? I'm going to tone it down. We reiterate here what we said in Boyd. It may well be argued that peace officers are not always well acquainted with our rules of evidence, and that statements such as the one here are merely inadvertent. I'm going to stop the quote for a second to say something, which is, again, here we have a peace officer, here we have an investigator who is well seasoned. The quote continues, but if we refuse to reverse this judgment, then we provide no incentive to district attorneys and solicitors to counsel their witnesses, especially law enforcement officers, to avoid extraneous and inadmissible outbursts. It is high time that this court go on record as opposing without reservation such conduct by law enforcement officers. Posey is exactly on point. Posey calls for a mistrial. This officer should have known better. The state should have properly prepared the witness to not issue, to not blurt out, to not state so clearly that my client was just getting out of prison. It cannot be corrected, Your Honor.
All right. Any last words by the state? Well, actually, never mind. It's the defense's motion, so y'all don't get any last words. All right. I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness as a law enforcement officer should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion, but given that the jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. What I am proposing to say as an instruction is Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 and should not have been mentioned. Further, this witness, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's criminal history should not be considered in connection with any of these other defendants or any of the charges against them in this case.
Your Honor?
Yes, sir.
I would also then, because we didn't have the opportunity to cross-examine, so it would be a confrontation clause, it would be reversible error. So I'm moving.
Let me ask you this. Have y'all cross-examined him the
Yes.
2 times before?
Yes.
All right, so we're going to strike everything
Yes,
he
that's
said
what I was,
today.
and
All right.
the notes, just like you did before, all the notes, they have to go back, give them to the court if you don't mind. Put them under seal, or that's what I remember you doing, but whatever you did with them. And if they can't follow that instruction, please alert your honorable court if you don't mind.
You're right. Can we just ask that we could just stop our testimony and give them an opportunity to cross-examine him?
No, I guess you can ask, and the answer is no.
But I don't.
The answer is no. You can make a record.
Yes, Your Honor. Your Honor, I don't believe that he and my question was broad.
It's not your fault.
And I understand that, but Your Honor, the testimony that was given today, this was a one-time infraction, Your Honor. And we would just ask, we can understand that if his testimony, if the state no longer can question him, we would ask that all of his testimony from today is not stricken because of one mistake. Like, this was one mistake that he made, Your Honor. We would stop our questioning of him, allow the defense to cross him on what has come out now, but all of the information that he's provided this far, he has been careful. He has not said anything today that was even remotely close to what happened here right now. I believe it was a mistake on his part. Maybe as a state, I should have instructed clearer, and I will take that responsibility, Your Honor. But given that this was one moment in time, the state is going to ask that we will stop questioning. If that's the sanction that the state has to stop questioning him, Your Honor, we will take that sanction and ask that the defense be allowed to cross him and that we be not allowed to direct him, and that's fine, but not that his entire testimony from today be struck, Your Honor, given that that was one mistake that he made very short in time, Your Honor.
All right,
we would
understood.
Just ask that.
Do I need to respond to that, Your Honor?
You don't
Okay.
need to.
Thank you.
Your Honor.
Yes.
I did not mention it, but also all the exhibits admitted through this gentleman need to be taken back under seal as well and disregarded by the jury, please.
All right, so as you can see, that was a huge win for the defense. Not only did they get a sanction and his entire testimony for today to be stricken, they also got them to remove and take from the record any freaking exhibit that he entered into this. Now, this was key and this was huge because he was connecting the dots that started the war between If Gang and YSL. They started out the testimony by showing footage of YSL members getting beaten up at a strip club. They showed footage of different instances that would make this thing spiral and make one gang go against YSL. Now, YSL hasn't been proven to be a gang, but clearly one group of people against another group of people, he was connecting the dots and connecting that this happened, and then this retaliation happened, and then this happened, and then this retaliation happened. His testimony was extremely strong. So the fact that they were able to get, number one, his entire testimony stricken. Number two, they had to, all of the notes that the jury took, she instructed them to shred them and they could not take them back. Number three, all of the exhibits that they entered in, which is the video footage of the beatdowns, the video footage of the interactions between the two, the photos that they showed that connected, this happened, then that happened as a retaliation, then this happened as retaliation. The fact that they were able to get all of that wiped out, it took away, I want to say, like 3 days of testimony, because basically what happened is they put up, like I said, they put up YFN Lucci's mama, they put up Little Woody's sister, they put up the old lady, they put up Little Woody's stepdaddy-in-law for the baby mama. They put up all of those witnesses who gave testimony, and he came in to tie all of those things together. He was putting all of the pieces together with his testimony, because when they just testified alone, it seemed irrelevant. It seemed like, okay, well, why are they introducing this? Why are they introducing that? And then when he came in, he was able to connect the reason why all of those witnesses were necessary. So the fact that they were able to get his testimony stricken today, that basically eliminated the testimony that seemed irrelevant but became relevant through his testimony. It was a huge win for the defense. Now, again, people, they get mad when you don't say team YSL, and you don't look at it with an objective lens. I'm not one of those people. I'm not a stand to nobody. I'm able to look at something. These people have no ties to me. They're not my family. I do not get majority of my income by kissing up to Young Thug. I don't get none of my income kissing up to Young Thug or any of these celebrities. So I'm going to call it how I see it, and I don't care who's mad. The state, in the beginning of testimony, they were doing very well for today, in my opinion. Now, Miss Love, she's corrupt. She do shady stuff. They do a lot of irrelevant testimony. There's a lot of stuff that they could have done without that witness, this witness, that witness. They could have done without a lot of the stuff. But today, I feel like they were making a lot of headway. They were breaking a lot of ground, and the defense came in and struck it all out and got it up out of here. So therefore it was a big win. Now let me go to the part where she gives the jury their instruction. They basically try to come up with what is the best instruction to present to the jury. And so let's pick back up right there, and then we'll be out.
It was not bifurcated, Sean.
Did nobody ask that it be bifurcated?
This has been a long trial, and I know you're not asking about my client's charges, but my recollection.
I mean, I guess that can just do for now, and we can get into the nitty-gritty of it with regard to RICO later. Before we have your testimony, so do you mind just hanging?
All right, so now she's going to instruct the jury on the goings-ons that went on. Oh, and one last thing before I show that her talking about the sanctions, you can support the channel via Cash App or by sending in a super thanks. Now, a super chat is what is done while I'm live, and those are the people that are with me live right now. Big Ham, John Y, Kayla, Roxy, all of the people who are watching with me live right now, they can send in what is a super chat to support the channel. Now, if you're watching this after I'm no longer live, you can also support the channel by way of a super thanks, and that is similar to a super chat, but in the comment section. So you can support the channel that way, and you can also become a member to the channel. Now, member, I don't put a lot of member stuff like behind the scenes on my channel. I need to start doing that, but there are still benefits to being a member, and that is your comments are always highlighted down below in the chat. If there is a viral story that I cover or a viral video where there's like thousands and thousands of comments, any of my members will be highlighted. Their comments are highlighted towards the top, and I'm going to make sure that if there is something like good that they say or whatever, it gets a lot of recognition and all of those things like that. So those are ways that you can support the channel. Now let's continue. Thank you so much, Roxy. Thank you so much, Michelle, for the donations. I appreciate y'all so much. Shout out to Roxy. Shout out to Grape Tea News. Shout out to all of y'all in the chat. I appreciate y'all.
I am sorry for the delay. I need to give y'all an instruction. Defendant Kendrick's prior criminal history has no relevance to this case except as to count 63 in Overt Act 189, and it should not have been mentioned by retired Investigator Dennis. And further, Investigator Dennis, as a former law enforcement officer, should have known better than to make any mention of it. Likewise, Mr. Kendrick's prior criminal history should not be considered in connection with any of the other defendants in this case. I'm going to strike the testimony of Investigator Dennis that was given today. You're to disregard today's testimony and the exhibits admitted through Investigator Dennis today in their entirety. We'll collect your notes from today and shred them. If there's anybody that is not going to be able to follow those instructions, please let the court know that now by raising your hand. Everybody good? Okay.
Yeah, Coach.
Yes. And he's all we've heard today so far. Anyway, we're going to hear some further testimony from other witnesses. So just I know some of y'all are trying to conserve paper, so we'll do the same thing we did before if anybody's written on both sides, but otherwise, is that what your question was going to be? Okay. All right. So just flip to a new page now, and we've got a couple more hours, and we'll just collect them at the end of the day. All right. Okay. Call your next witness.
Do I still call Officer Rogers then?
What's the last name?
Rogers.
Okay, thank you.
All right, y'all. So they're now on to the next witness. And that concludes this video. I appreciate everybody for tuning in. I just wanted to focus in on the big win for the defense and give my little 1-2-1-2. Again, I'm not if you are doing bad acts in the community, you shooting up people's homes, and you are out there being a menace to society, I don't care which celebrity you're tied to or what status that you got behind you. If you're out there being a menace, then you deserve to be held accountable for what you got going on. However, I just do not believe in the tactics that the state are taking to prove their case. I believe that they do have evidence that shows guilt on a lot of these people. They just need to stick to the ethics and the points that prove their case. They already know that they do not have willing or participating witnesses, so they have to focus on the stronger areas of their case that proves the guilt of some of these defendants in this case. Now, again, I don't think that they have proven that Young Thug is this big mob boss type person that's running this criminal enterprise. However, I do think that they do have evidence that shows the guilt of some of the defendants. And if they're able to focus on the key points, stop throwing out anything that they can on the wall to see what sticks, and just focusing in on the pertinent parts and the strong parts of the case, then they will be a lot better off and a lot further along. However, no matter how concise they are, I don't think that they are equipped to go against the powerhouse defense attorneys. Brian Steele is a powerhouse. Max Shard is a powerhouse. Doug Weinstein and all of the defense attorney, well, not all, but most of the defense attorneys are big powerhouses, and together as a collective, they are a big force to go against. So I think that they need to really, really, really tighten up and get it together, because, people are going to continue to side with how they side. At the end of the day, you're supposed to be innocent till proven guilty. And that's that on that. It looks like to me, I don't know if the attorney DA Love has been demoted, but you can definitely check. You can definitely see that they put her on timeout. Okay. Thank you, Issa, for the membership. I appreciate you so much. You can definitely see that attorney DA Love has taken a back seat, whether it be temporary for a week, but they done tap that tail. Okay. And so now they are calling in other DAs to help. And it just goes to show that they need to tighten up, and they need to really, 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 really focus on the matters at hand. You said, Neek, I DM you on Instagram about this woman. About which woman? About which woman? Let me see. But with that being said, I'll talk to y'all on the next video. I'm going to continue to look at this case objectively. I don't care who's mad. If the state makes a good point, I'm going to call it out. And if the defense makes a good point, then I'm going to call it out too. And it is what it is. I'll talk to y'all on the pudding hot. Okay. I'll check it out. See y'all later.